Big shout out to Tommy V in Michigan. He was on fire this morning.
Okay, thank you, Tommy V in Michigan. Yes, sir. If you share my prayers.
Tommy V's on. Yeah, we'll jump over there. How about that?
Correct.
Okay. This is for non-payment of rent?
It's for
non-payment of rent?
Yeah.
But there's reasons for that.
Okay, and I was gonna say, you believe that you have a lawful defense to why you withheld your rent?
Yes, ma'am.
Okay, and you have your evidence today?
I have some here for you.
Okay, when's the last time they paid rent? I'm asking him a question, not you.
They've never paid it.
Okay, when did they move into the property?
They moved in the property November 1st.
November 1st? I'm talking to him. They moved in when?
They moved, well, we had an agreement that they would, because they didn't have any money.
I just want the answer to my question. They moved in when?
They moved in on, I have it on November the 1st.
November 1st. And how much was their rent supposed to be?
Okay, the rent was supposed to be $850 a month, but I wasn't can I add something?
Okay, they were supposed to pay that beginning November 1st or when?
Beginning of January 1st.
Beginning January 1st. So they moved in November 1st. There was no obligation for them to pay rent for November or December, correct?
Correct.
Okay, January 1st, okay.
And then I extended that out because they were doing improvements on the property.
Extended what out? The date that they needed to pay rent?
Yes.
When you say you extended it out, what does that mean?
That means that I gave them more time before they started to have to pay rent.
Okay, so.
I extended it out to February 1st.
And that's because they were making improvements to the property?
Correct.
Okay, so your position is that they've not paid February, March, and now April rent?
Correct. And it's all been written in the lease that I submitted.
You have a copy of your lease?
I do.
Okay. Any other? February, March, and April.
So I gave this to kind of explain.
You did present this letter. I'm not reading the letter. That's what you're here for. So if you want to testify as to your position,
okay.
But he's going to get any paperwork from you. You must ask permission to approach the bench. You can go back there.
Okay. Okay.
You all can have a seat while he's presenting his evidence. Okay, I see this is a summons. You don't really need that. That should be part of the file. I don't know what he has there. This is a summons. That is a letter. Which one is your lease, sir? Okay, residential lease. We will give him that one back. I see here, you did cross out February, with 30 days notice when leaving or when needed to vacate. Let's see, tenant must pay landlord as rent for entire term, a total of $10,200. $850 each month, beginning February 1st, 2024, and the first for each month thereafter.
It's a month by month. It was a month by month agreement.
Okay, if it's a month to month agreement, why is there an entire term amount for $10,200?
I was probably confused about it.
Okay, any additional evidence, sir?
Nope.
Okay.
And that's the agreement of what they were to fix up while we were staying there.
Okay, thank you. Okay, and who wants to go first?
I would like to go first.
Okay.
I don't know
What's
if you did.
your name again, sir?
My name is Michael Kelly.
Michael Kelly, what is your lawful reason as to why you don't believe you owed rent for February, March, and April?
Well, actually, it's, the reason being is the work that we performed for him, and the stuff that I had purchased for the home, this was before that was even signed, that Mark didn't follow up for. Now, when he found out, when the inspectors came in, and he found out that he's got to spend $10,000-$15,000 on a new roof, well, everything changed. I've got stuff that dates back before that lease.
What was your agreement?
It was till June.
But what was your agreement?
Our
As
agreement,
you signed the lease.
our agreement.
Did you sign a lease?
I did sign the lease.
Okay, and you signed the lease that you would pay $850 beginning February 2024?
Yes, ma'am, but that was also with the understanding that Mark was going to pay for these materials that I put into his home.
Where was that understanding in writing?
I have the sales receipt right here for the
I
materials.
understand you have a receipt in your hand. Where was that
It was, ma'am, it was on,
agreement in writing?
it was on a handshake, ma'am. It was a verbal agreement between us. I mean, the house was totally, had to be regutted, the whole kitchen, everything. We had to redo all the plumbing. I mean, everything was redone in the house.
Is that your signature?
Yes, ma'am.
Okay, this was signed October 25th, 2023? This agreement?
October?
October 25th, 2023 is what this says. You signed
Yes.
it, the date says October 25th, is that accurate? October 25th, 2023? Okay, this says it's an addendum to the rental agreement. Because of special circumstances, namely the needs of the renters to obtain housing by November 1st and the need for the landlord to make repairs on the property so it's livable, it is agreed that Michael and Becky Kelly shall make repairs to the property until it is suitable as a rental. This is not to make upgrades and structural changes to the house, but to make repairs on existing surfaces and structures so that they are fresh and functional. These include 1/2 roof repair, shingles provided, it says $900 for shingles, and nail gun. It says I gave Mike $900 cash on September 25th, 2023. I also let him borrow my air compressor. It says there's a note here, repair was never made. Kitchen sink provided, bathroom fixture, toilet and new valve for bathroom, flooring provided. Drywall repairs in the kitchen and bathroom, drywall provided, 4 sheets. It says replace door in back room, door provided. Repair ceiling in bedroom, drywall provided. Paint walls throughout, paint the equipment provided, 2 gallons of Kills. It says install carpet throughout, carpet and glue provided. Replace support beam on back porch, beam provided. Repair lean-to structure in backyard, wood provided. It says Mike and Becky will pay the utilities, consumer and board of water and light while the property is being repaired. It is agreed that they may live in the house while they work on these repairs. In exchange for their labor, I will waive payment until January 1st, 2024. That's 2 months, November and December. It says or, but it probably means of 2023. Starting in January, the tenants will pay $850 rent in January and thereafter, as well as continue to pay for utilities. In addition, Michael, in lieu of a security deposit, must leave property in rentable condition when he leaves. Again, that's your signature there?
It is, ma'am.
Okay, so what about this agreement do you think that I need to now add after you have signed this on October?
Okay, this happened before October.
Well, then it should have been in your agreement.
It should have. It should
And
have.
it was not, so I don't want to hear about it.
I didn't write that up.
You signed it.
I
You had every right
understand
to-
that. That's my fault. That's my
Yeah, and
mistake.
it's definitely your mistake because when you negotiate a contract and you sign it, you have the right to put those terms in there or else you don't sign it. So if you signed it and it's in pretty explicit detail about what was provided, what you were going to pay for, what you were not going to pay for, what he's going to cut off. And you could have always said, no, you didn't provide, you didn't refund me for these. I got these receipts. So you can't come now after you signed an agreement in October.
Well, I understand.
And you're cutting me off. So
Sorry.
judgment in favor of the plaintiff for $850 for 3 months rent. You have court costs?
Do I have to write it up? Or?
No, I'm asking you what your court costs were. How did you serve them?
I served them through a processor.
How much was the
$65. And then there was the fee to file.
$55 for filing. He said there was, what was it? He said process server. Do you know the amount it costs for you to serve?
65.
Possession to the plaintiff in the amount of $2,670 for the months again of February, March, and April of past due rent, plus that includes the court costs of $120. That's for service and the filing fee. You need to pay that or vacate by April 22nd. That's the writ date. You all negotiate a date beyond that. That's between the two of you, but that's the statutory time frame, 10-day period. Any additional matters for the record?
I know you're on.
No.
Thank you. You're all set. We'll get you a copy of this paperwork.
Thank you for your time today.
You're welcome. Mr. Whitty, you have which matter? Okay. Assuming persons is represented by legal services?
Yes.
Okay, on the record in the matter of Blair Bears versus Gabriel Parsons, file number is 24-00288. Counsel appearance.
Good afternoon, Your Honor. Don Kesky from the plaintiff.
Alyssa Hull with Legal Services for Defendant Parsons.
Okay, I have a concern. I'm going to make it very clear. They're represented by counsel, correct?
Yes.
You've been talking to counsel on this, or you've been talking to the client?
I've been talking to the client.
And you
Yes.
understand that that is outside of your professional responsibility, correct?
I understand. I've been directed by his counsel to do so.
He can't direct you to not talk to him when you're represented by counsel. That's why they have counsel representation. And we don't need people who are not licensed to be acting as if they're counsel when they come to court.
Understood, Your Honor.
And that's been my concern today. The clients should conduct themselves as clients when they come in for hearing and not co-counsel.
Well, Your Honor, as they were negotiating the terms, I did check him on 2 occasions. Once in the council room, out in the hallway moments ago. I reviewed the consent order, conditional dismissal, and have confirmed with my client, this is agreeable. It's agreeable to me. I think it's in order.
I recognize that, but you are representing them in this case?
Yes, I'm.
So it's not your duty to check in on another attorney talking with your client. It's your professional responsibility to be in there talking to the client directly, correct? Or is that a misunderstanding of the professional responsibility?
Yes, and I believe I've carried that out, but I have also want, Your Honor, that the client makes the ultimate decision as to.
I recognize that.
And lots of times the negotiations happen not only on the court date, but before by email, phone calls, or discussions. So sometimes in some cases, these are ongoing efforts.
I recognize there are ongoing efforts and they can take place, the negotiation can take place in court, they can take place outside of court. But when someone is represented by counsel, attorneys speak to other attorneys. They no longer can speak to the client who's being represented. Same way you can't speak to her client because he's represented by counsel. Otherwise, it's a violation of the rules of professional conduct, correct? If you speak to her client,
And I haven't.
would that be a violation of your rules of professional
I think
conduct?
The protocol is that
I'm asking you a very direct question. Is that a yes or a no? If you speak to her client, are you violating professional conduct?
Well, if the attorney's not given permission and is not present, yes.
Correct. And so have you spoken with him with his client without him being present?
I have spoken with his client without him present, but he did give permission.
But you're not present. And you stated the rule accurately, but you didn't follow it. You can't send your client in a room to negotiate with an attorney when you're the attorney on the matter. You can't do it. And I don't care if you do it in other courtrooms, you're not doing it in courtroom 4, okay?
Okay,
Place the terms on the record.
in terms of the consent order for conditional dismissal of this death, in paragraph 3, the defendant will move out and return the keys on or before May 24, 2024, and the counterclaim filed by defendant is withdrawn.
Is that complete and accurate, counsel?
Yes, it is, Your Honor.
Okay, can you approach with the agreement? Okay, and Mr. Parsons, you understand that you have the right to demand a trial in this matter.
Yes, ma'am.
We also have a counterclaim that you have pending. Are you willing to waive your right to a trial?
Yes, ma'am.
And you're also withdrawing your counterclaim?
Yes, ma'am.
Okay, so you are agreeing that you will vacate the property and turn over the keys no later than May 24th. Is that accurate?
Yes, ma'am.
Anybody threatening you to waive your right to trial?
No, I don't.
Okay, any promises being made to you if you waive your trial?
No, I don't.
Okay. Partial performance won't satisfy this. That means you have to move out all of your things and turn over the keys by that date, not the day after, and not leaving any things behind, including trash. You understand that?
Yes, ma'am.
If you don't follow this agreement fully, they can enter judgment against you without noticing you for a next court date. You understand that?
Yes, ma'am.
Do you have any questions?
No, Your Honor, thank you.
We'll get you a copy of your paperwork. You have 3 business days to return to the court. If once you leave here, you realize you misunderstood the right that you waived, which is your right to trial, you can return to the court, request to have this set aside, and we'll set it for a hearing, okay?
Yes, ma'am.
Any additional matters for the record, counsel?
Just one question, that is, will the court be automatically filing this on my file, or do you want us to follow up and file these conditional dismissals on my file?
I'm already doing
We've already done them.
Okay, thank you.
Thank you, Your Honor.
Thank you.